With chapter number 18 from your history book of grade 8, and the name of the chapter is the Judiciary. And let's begin from the High Court. According to the Constitution, each state in the country can have a High Court, which is the highest judiciary authority in that state. Some High Courts have two or more states and union territories under their jurisdiction. What is the composition? At the highest level is the Chief Justice. There are a number of other judges, as this number is decided by the President according to the size of that state. The President appoints the Chief Justice of the High Court and the other judges in consultation and with the Governor of the state and the Chief Justice of India. The qualification of the judges of the High Court are: they must be citizen of India, they must have held a jurisdiction office in India for at least 10 years, they must have been for at least 10 years advocates of a High Court or of two or more other such courts in succession. Judges of the High Court serve until they are 62 years old, although they can resign earlier or can be removed from office by the President if they are impeached by the same process that applies as to the judges of the Supreme Court. What are the powers of the High Court? The High Court is the highest court of justice in the state. A High Court has original jurisdiction, that is, it can hear original cases brought to the High Court for the first time, and these cases can involve disputes concerning fundamental rights, election petitions and related disputes. Yes, a High Court has appellate jurisdiction, where it can hear appeals against the judgments passed by the subordinate courts, also such as the district courts. The High Court can review and change the decisions taken by the subordinate courts. It can transfer a case from one court to another court also. A High Court also controls and supervises the functions of the subordinate courts. It has revisory jurisdiction, and in cases where it feels that the lower courts have gone beyond their jurisdiction, and it maintains records of the proceedings and decisions. These records serve as references as for lower courts in further cases. What are writs? Both the Supreme Court and the High Court are empowered by the Constitution, means having the power given by the Constitution of India to issue writs is for the enforcement of the fundamental rights. A writ is a form of written command or a legal document giving order or direction to a person to act or not to act in a particular way. Some of the writs you can say the writs are habeas corpus, mandamus, prohibition, and certiorari, quo warranto, and etc. So, what are the meaning? Habeas corpus. The Supreme Court or High Court or High Courts can issue the writ to somebody who has detained another person illegally, commanding him or her to bring the person into the court and to state the cause of arrest of him or her. Mandamus. This writ is issued to compel the lower court or an official or individual to perform their duties in certain acts or in certain way. Prohibition. And you can say this writ can prevent a lower court from exceeding its jurisdiction and keep it within the limits of its own jurisdiction. It can be used to check misuses of powers also. Certiorari. This writ can be used to compel lower courts to hand over the records of a particular case to a higher court. Quo warranto. This writ can be issued against a person who has wrongfully occupied an office. Subordinate courts. Beyond each High Court, there are several lower courts, each known as the subordinate courts. These courts are under the control of the High Courts. There are three types of subordinate courts. One is the civil court, criminal courts, and the revenue courts. Panchayat courts. In the Panchayati system at village level, there are small law courts called Na Panchayat, or you can say Na Panchayat. And often there is one Panchayat court for a number of villages. Na Panchayats try small cases, petty or small civil and criminal cases such as trespassing, personal disputes, minor thieves, etc. They can impose fine up to rupees 100 only. Appeals can be made to higher courts against decisions taken by the Na Panchayat. Lok Adalats. The process of obtaining justice through law courts is a lengthy and expensive procedure in our country. In order to provide quicker and cheap judicial services, Lok Adalats have been set up. The first Lok Adalat was held at Delhi in 1985. It settled almost 150 cases in one day. Lok Adalats are usually presided over by the retired judges. The disputing parties can argue their cases directly without advocates. Decisions and persuasions and compromises are encouraged to settle disputes. Lok Adalats are becoming popular because they provide affordable and speedy justice. Next, we are having legal aid. According to the Indian Constitution, all citizens are equal before the law, irrespective of caste, creed, social status, as gender or religion. Under the legal aid scheme, free legal aid and legal services are made available to the poorer and weaker sections of the society. Some of the categories for which free legal services are provided by the government are people belonging to scheduled castes, scheduled tribes and other backward classes, people with special needs, women and children, victims of human trafficking or beggars, people whose income are lower than the certain amount decided by the government. So the Indian judiciary has been designed to impart justice to all the citizens in functioning, and it functions independently of the executive and the legislature, so that it can work impartially and free from the influence of other organs of the government. Thank you.